You're listening to Soundside. I'm Libby Denkman. Over the last 3 years, the shortage of public defenders in Washington state has built to a crisis. It's been taking a toll on the lawyers who represent clients that need representation but can't afford it. Since that representation is promised in the U.S. and our state constitutions, these lawyers are a critical aspect of the legal system. And when there aren't enough lawyers, people wait in jail. Last year, the ACLU of Washington sued Yakima County for denying defendants their Sixth Amendment right to an attorney. The county has struggled to hire new public defenders for years. To address the lack, public defenders proposed a counterintuitive solution: lower the number of cases public defenders can take on. They say doing so will reduce burnout and increase recruitment. This month, the Washington State Supreme Court signed on to dramatically reduce caseload limits for defenders. Daniel Beekman is a reporter at the Seattle Times and has been following this story. Thank you very much for being back on the show, Dan.
Thanks for having me.
So the public defender shortage has been an issue for years. We have talked about it on the show before. Tell us, what is the impact of inadequate staffing at a public defender's office?
Well, for one thing, it has an effect on the public defenders themselves. It means they're really busy. They're taking on a lot of cases. It also affects they're working long hours. It also affects the clients, the defendants, who have public defenders as their attorneys for their criminal cases. It means they may not be able to see their attorney when they should. It means even when they do see their attorney, if that attorney has too many other cases, they're not really getting a lot of time with that public defender. Sometimes people in Washington state in recent years have been sitting in jail for days, weeks, without attorneys at all to represent them. And even when people are attorneyless and they're not in jail, when they're out on bail or otherwise released, and they're going through their court proceedings, when they lack a public defender for that day in court, that means they just have to postpone it and come back, 2 weeks, a month later, and their case drags out. This is a case that they're trying to get through and get done with so they can move on with their life. Yeah, so it also affects prosecutors. If there's no public defender, it makes it hard to prosecute a case. And in some points in Washington state, in some courts, the lack of public defenders has sort of grounds the justice system to a halt completely. People have been released who are facing criminal charges because there's no one to represent them. So it can be a real mess.
Yeah, and in Yakima, the case I cited that the ACLU sued over, they said people were waiting in jail for more than a month and then out of jail for months for representation. So the solution that the public defenders put forward sounded a little bit backward, basically reducing the number of cases, taking on fewer cases in order to what, Daniel? I mean, what's the reasoning here to limit the number of cases public defenders can take on?
Sure. Well, so one part of it is relatively straightforward for public defenders, which is they're saying we have too much work, we can't do a good job, and we're working 24 hours a day, that kind of thing. So reducing the maximum caseload that they can handle means they're going to have fewer clients to be able to do better work and have a more manageable life. But in terms of how it could address the root of the problem, it kind of goes like this. The public defenders and other proponents of these lower caseloads say that a big reason for the public defense crisis of having a shortage of public defenders is because nobody wants to do the job. There are fewer people coming out of law school. There aren't law schools all across in every community across our state. And so there's this pool of people mostly coming out of Western Washington, newer attorneys, and they're looking at these massive caseloads, massive workloads, really tough jobs and saying, I think I might do something else. And so the argument here is that by lowering the maximum caseloads, making the job more manageable and attractive, in theory, over time, that means more people will want to get into the business. And you can, even though in the short term, you have to hire more attorneys during a shortage, over the long term, more people are coming into the profession and staying rather than burning out and leaving. And so then you get a fuller complement of staffing, and that starts to improve the big picture problem.
On the other hand, counties, which pay for public defenders, I mean, they push back against the proposed caseload limits you report. Why were counties such fierce opponents of this change?
Yeah, it's interesting. I mean, on one hand, the counties agree with public defenders that the current situation isn't sustainable, that there's a big problem. And actually, the public defenders generally and the county officials generally agree at pointing the finger to a large extent at the state legislature, saying the state of Washington hasn't adequately funded public defense, and that's a big another big problem here. But where the counties and some of these public defenders disagree is about how to address the problem right in the here and now. Where the argument from the public defenders goes, as I was saying, that if you reduce the caseloads and make it more attractive as a job, that will help resolve the staffing shortages. The counties say maybe theoretically in the long term, but in the short term, right now, if we're already short on attorneys, especially in rural areas and rural parts of the state, and then you reduce the caseload limits, meaning potentially tripling the number of attorneys you need for the same number of cases, then you're going to make a staffing shortage that already exists even worse. And they also are just really concerned that even if they could find triple the amount of attorneys to hire, they couldn't afford to pay triple the amount of attorneys because the state isn't funding public defense. So the counties are just start screaming and saying, "Hey, we get there's a problem. We even to some extent sympathize with you, with public defenders, and what you're going through. But if this change goes through overnight, A, it's going to break our justice system. B, it's going to break our budgets."
Yeah, and speaking of budget, the legislature passed a new 2-year one earlier this year, and they doubled the amount of money that the state will be sending to counties for public defense. I mean, is that going to make a dent here?
I think what the counties would say is that it's going to help, definitely, and help staunch the bleeding a little bit, but it's not going to fix this problem overnight at all, because even though the legislature, with this new budget is doubling over the next biennium what it has been sending to counties to help them pay for public defense services, that's still going to be well below 10% of the cost the state is funding. And that's a real contrast with, I think, a majority of the states in the United States. The state basically pays for public defense. Whereas here in Washington, almost all of the costs, still, even with this boost from the legislature, 90% plus of the cost is borne by counties and cities. And they say, what makes it even more unfair is at the same time that the state is saying, you guys have to basically foot the bill on your own for public defenders, which is, again, guaranteed in the state constitution. Beyond that, we as a state are going to put constraints on your ability to raise taxes to pay for that. So, the counties have been screaming about this for a while. They've sued the state over this, and that case hasn't been resolved yet.
Yeah, we've talked to local governments and their representatives trying to lobby for some kind of give there when you talk about their ability to raise revenue and the increasing costs that they're facing, big budget problems at the local city and county level. So, Daniel, we're hearing from public defenders that the status quo is already breaking the legal system, people waiting too long for attorneys burning out. The counties are saying, well, if you limit the number of cases that the existing public defenders can take, that's going to break things even more. Now, this month, the state Supreme Court seemed to side with the public defenders. They adopted this new caseload limit. So what's happening here? What did they decide, and what are the limits?
Well, the way I read it, the state Supreme Court trying to sort of balance all these different interests and also address sort of the base constitutional questions here, which is that if you can't afford to pay for your attorney, you deserve adequate representation. They're looking at all those things, and I think kind of where they came out is somewhat of a compromise. So they, in a sense, sided with public defenders and said, we are going to dramatically lower the maximum caseloads in terms of the court rules here in Washington state. So the old rules limited defender caseloads to 150 felonies or 400 misdemeanors per year, or some mix of those two things. But to give you a sense of the scale, 150 felonies or 400 misdemeanors, the new rules will bring that down to 47 felonies or 120 misdemeanors. So it's a really dramatic reduction. But there are details that show the court trying to sort of take a more practical compromise approach. Although they're siding with the public defenders on lowering the caseload limits, they're saying, okay, counties, we're going to do this, but we're going to give you up to 10 years to get to those numbers. You have to every year at least reduce your maximum caseloads for public defenders by 10% annually. But, if you do the minimum 10% every year over 10 years, you'll get to this new standard. So we're going to give you time. We're not going to make you do overnight. That's one piece. Another piece is that the public defenders, this gets a little bit wonky, but
you're on NPR, lay it on us.
okay. So like all misdemeanors and all felonies aren't necessarily created equal in terms of the amount of time that prosecutors as well, but also public defenders have to spend working on them. Like a really egregious murder case, a homicide case, like life imprisonment, a homicide case will take more work for a public defender than another felony that's still serious enough to be a felony, but it's a lower level crime. And so there's this thing called case weighting in the field where one felony is sort of let's say a really serious felony is weighted at 3 times more than a non-serious felony. And the same thing goes for misdemeanors. And the public defender said, in establishing these new caseload limits, we want you, the Supreme Court, to require all jurisdictions to use the same case weighting. So, and what that means in practical terms is even though the sort of top line maximum number of felonies a public defender could do in a year would be 47, if they were doing, let's say, all homicide murder trials, then maybe they could only actually do a maximum of 8 cases. So 8 cases in an entire year. So if you're mandating case weighting, that further could reduce the number of cases the public defenders would take on. And the Supreme Court said, we agree with that in theory. We think case weighting makes sense. We encourage counties to use it, but we're not going to mandate it. With those two details, the giving the up to 10-year timeline to counties and not mandating the case weighting, the Supreme Court sort of tried to thread a needle here by saying, hey, public defenders, we agree with you. We're going to lower the caseload maximums, but counties, we hear you freaking out. We're going to give you, up to a decade to make this work and gradually, and we're not going to mandate case weighting.
I imagine that some people might say, if you're on the public defender side at least, well, this is a start, but it's also in a sense kicking the can down the road, because if you have more than 10 years to get this done, in the meantime, you're going to have a lot of people leaving the profession, getting ground down by the burnout. So I guess my question to you, Daniel, is this kicking the can down the road?
I definitely heard from some public defense folks that they're saying, look, this is a crisis. What crisis do we wait 10 years to solve, was what one of them told me. And there are some, angry folks out there who thought and wanted the Supreme Court to be more aggressive. But I also heard from folks who even if they agree with sort of the public defender standpoint, said, look, the Supreme Court was in a tough place. They're trying to strike some kind of a balance here. It's pretty clear, like the court, making this rule isn't necessarily going to change things and solve the problem in every community in Washington state overnight. On the other hand, it is setting a new standard that's very different for the long term. Even if it takes some jurisdictions 10 years to get there, there's a possibility that then that will be in place. That new standard will be in place for another 10 years and another 10 years after that. So it is a long-term win for public defenders, even if it's not necessarily going to be a short-term win everywhere for everyone.
This has been a conversation for years in Washington state, and you've been following it really closely for the Times. Now that the caseload limit has been changed by the state Supreme Court, is this the end of the story for you, or what kinds of things are you going to be following as the ripple effects play out?
I don't think it's the end of the story. I think there'll continue to be challenges. And of course, the caseload limits are only one part of the equation in terms of this problem. There's also like the law schools, and there's the legislature with the funding, and there is also, frankly, the number of cases being filed by prosecutors. Some public defenders, very, sort of reform-minded public defenders will say, hey, one way to solve this problem is to charge, fewer people with crimes, try to divert more people out of the justice system in the first place, so that we don't need prosecutors or public defenders for their cases. So there's a lot of factors here to follow, and it's also really difficult because each jurisdiction, each community in Washington state has different resources and sort of a different way of handling all of this. Like King County, just for example, even though the Supreme Court is giving communities 10 years to get there, King County is already moving on a much faster timeline to get there, partly because it has more funding and more wherewithal to do that. So one of the things I'll be watching is, how is this working in King County, but also how is it working in Asotin County,
Yeah.
way over in Eastern Washington, or Ferry County, or some of these very small rural counties without the same kind of resources as in the urban Western Washington area.
And how do you get that community to be attractive to a young law school graduate who's going into public defense? Daniel Beekman, reporter at the Seattle Times, covering this new caseload limit for Washington state adopted by the Supreme Court this month. Really appreciate your reporting as always, Daniel. Thank you.
Yeah, thanks for having me.
And by the way, we also reached out to Bob Berukowitz to get his thoughts on the new caseload limits. Berukowitz is a professor from practice at Seattle University School of Law and director of the Defender Initiative.
I'm actually a combination of excited and just a little bit disappointed.
He's excited that the court recognized the need to reduce caseloads. He says this will give defenders more time to adequately represent clients.
What I think is so great about this is a recognition by the court that the existing court rule, which was also great when it was adopted, of limiting defenders to 150 felonies a year or 400 misdemeanors, that is way too high.
His little bit of disappointment comes from the 10-year timeline the court gave counties to implement these changes. Though he says that isn't set in stone, the court will review the changes in a few years.
My hope is that we'll be able to develop information for the court that will persuade them that they need to accelerate the 10 years and that there hasn't been any adverse consequence. In fact, it's all been to the good.
Ultimately, Berukowitz says he's hopeful that this move will necessitate expanded alternatives to the criminal justice system, like mental health treatment and housing support.
Very often, the society has tended to treat the criminal courts as a place to put mentally ill people instead of making sure that we have adequate mental health treatment. So there's a lot that can be done outside of the traditional criminal legal system to get the cases out of court so that the lawyers don't have as many cases that they have to do.
Berukowitz acknowledges that public defender caseload limits won't bring around this change alone, but they could be a start. Thanks for listening to Soundside. By the way, this show is only possible because listeners support us. If you are able to give right now, check out the show notes for a link to donate. And don't forget, you can listen live on KUOW 94.9 FM Seattle at noon and 8 p.m. Monday through Thursday, or anytime online at KUOW.org.